Good. Get this.
All right, looks like we are live. Welcome everybody to this edition of Legalese with John Watts and Stephen Palmieri. Without John Watts, John is out, I believe, fighting the bad guys, and in his place, we have the amazing Blaine Dixon coming to us from Tennessee. How are you, Blaine? Welcome.
All right. I want to make it perfectly clear. My name is not John J. Watts. I've never lied to the American people. Will never lie.
You are not a crook. Very good. Very good.
I'm not a crook. I'm not a debt collector. I want to make that perfectly clear.
Man, it looks like you had your Wheaties this morning. Well, thank you for joining us, Blaine, you and all of your humor. And so for those of you guys who may not know Blaine is a consumer protection attorney who now also you happen to now kind of be working with John's firm. You weren't always on the dark side, but you went over to the dark side. Now you're working with John. Is that right, Blaine?
That's right. Well, I'm not sure I was ever really on the dark side. I was never in the collection business. Unlike my friend Mike Cardoza, who literally came from the depths of collection hell to the light. But working with John Watts and Stan Herring as their Tennessee of counsel, I guess to be completely transparent, I'm not technically a member of the firm, but for purposes of Tennessee law, if you are in Tennessee and you need help with debt defense, you've been sued by one of these goblins like LVNV or Midland Funding LLC or Portfolio, or you go down and name any of the XYZ companies that come into our courts and file, then of course I have all of our staff and expertise available from Watts Herring, and so
that's like that. Talking about all these people, it sounds like you're a divorce attorney, practically speaking. My goodness, with all the hatred going on over there.
Well, we really are. I like to think that we will get you divorced from your debt, and the greatest thing, we will get you divorced from your debt collection lawyers, and we'll make sure that they don't call you, they don't scare you, they don't harass you, and when things go well, as they often go. If you're sued by a third-party debt buyer, we'll get involved, and oftentimes the courts will simply tell the debt collector, "Hey, great job! You get an honorable mention. Thanks for filing your lawsuit. Now we're sorry you can't collect from Mr. Dixon's client or Mr. Watts' client." And this is because they have to prove up their case, and quite frankly, when push comes to shove, the majority of the time they are either unwilling or unable to prove the debt.
Let's talk about that. And so for those of you guys watching us live, feel free to comment below. We do this for you guys as well. We're watching your comments. And so all right, so let's talk about that. Unable or unwilling to prove up the debt. Well, let's talk about the unwilling first. How are they sometimes unwilling, which would lead you to conclude that they're able, but they're not willing? So let's talk about that.
Well, okay, if you're going to assume that they're able, how many times have you seen a lawsuits filed, Stephen? I'm sure you've seen these, and they'll submit a stack of papers, an inch, 2-3 inches thick. There'll be inevitably there will be an affidavit from some alleged custodian of records, someone alleging to have firsthand knowledge of the information typically under the state's business records exception statute to the rule of evidence, which requires that certain aspects of evidence be proven up. And so to try to make that easier on themselves, the collection bar worked really hard and got our state legislature in Tennessee, and I think it's happened in many other states, probably in Alabama, where they have these statutes that claim that the records are sort of self-integrating or that they come in. But when you get right down to it, at least here in Tennessee, there is great case law from the Tennessee Court of Appeals from the Civil Division, which says basically it's not enough to just submit a stack of documents that claim to corroborate the plaintiff's case, but they've got to actually produce someone with firsthand knowledge, and they seldom can they do that. And often when they can, they will not go to the expense to bring that individual to trial.
So let's talk about that real quick, though. I mean, because let's back it up for a second. So, it used to be back in the day, I guess it still is, but you would send the debt collector a notice, give me something, and then they would print up this little half a page dot matrix thing that says, right. This was printed up in our backyard, right under the toilet paper machine, and this is the
right. 10 years ago, we used to see that, and then it kind of progressed to a Word doc with like a quasi spreadsheet done in Word with a bunch of names and everything redacted out, and then suddenly, my client, his or her name pops up, and a bunch of X'd out numbers, and then maybe the last four of an account, which is not sufficient on itself to prove anything other than they had in their possession those four numbers, which where they came from, they could have come from anywhere. Well, Tennessee has this wonderful case called LVNV versus Mastaw, where the court had said that those bare allegations of self-serving documents were not enough, and then that was followed up recently in the past couple of years by a case known as Converging Capital, and in that case, the Tennessee Court of Appeals adopted case law from a couple of other states. I think I believe that Missouri may have been one, possibly Arkansas, and they said that not only is it not enough to just have something that purports for business records, but they've got to come in and actually prove the veracity or the validity of every single link in the chain of ownership from the first, from the original creditor through anybody's hands that it is changed hands with. And that's been very useful for us because that's a burden that most of the time, even if they're able to meet it, theoretically, they're certainly not willing to meet it. If you, for instance, in Tennessee, if you take LVMV or Midland and you set a hard trial date, you set 10 of those for each of those, you will be absolutely astounded if you have more than a single trial out of 10 or 20 of those.
So why would they be unwilling to produce that chain of ownership if they are able to?
I'm sorry, can you restate that, Steve?
Yeah, sure. So I think you had just said that even if they're able to show like that chain of ownership, they're unwilling to. Did I hear you correctly?
Well, it seems they're unwilling to do the work necessary to do that.
Okay. All right.
Even if you give them the benefit of the doubt, so to speak, and there's always a lot of doubt. But my prevailing theory, and I think a lot of us in the National Consumer Bar, is that the big third-party debt buyers work on a default model. The model is this, and they know this from statistics, Stephen. And I'd like to be better prepared next time, but we know the numbers that nationally, fully, at least 90% of people who are sued on a third-party debt account, for instance, Portfolio Recovery or Midland, one of these companies, they do not even show up in court. So our job as consumer advocates, a big job that we have, one of the reasons we come on these national programs like yours, is to let people know, hey, you've been sued. So what? Don't be afraid. call one of us. If you don't call Watson Herring, someone. I mean, my goodness, reach out, call legal aid. We frequently have legal aid will reach out to us and say, what can you do for our clients? So, we do a certain amount of work where I know, for instance, I'll drive across the state and pro bono a legal aid case to give them a willingness to stand up for a trial where much of the legal aid bar, at least in the state of Tennessee, are not seem not to be well versed on how to try these cases.
So let's dial this back to kind of our viewer here, typically a credit repair organization. I'm sure we have some consumers watching as well, but specifically credit repair organizations. Okay, so as a non-attorney, well,
right,
even as an attorney, outside of litigation, you really don't have a mechanism under the FDCPA to like force up a chain of ownership. So let's talk about how our viewing audience here can benefit from their ability to be in touch with you and then to kind of pass the baton. Like, what does their sprint look like and what does your sprint look like? So your sprint is, okay, you've got a client that's handed off to you and obviously, in your opinion, clearly some sort of FDCPA violation, which could be any number of things. I mean, I guess it could be inability to, collecting on a debt that they can't prove, they don't have the lawful ability to, whatever that looks like. That's why you're the attorney. Reporting false credit information, including but not limited to failure to report disputed items as disputed. An account comes to you from a client and you're like, oh, I like this for any number of FDCPA reasons, and then you go ahead and sue them, and then you're like, provide this proof of chain of ownership and all this stuff.
That's important. I mean, what you're asking, and you have to understand that the vast majority of our clients come to us after having been sued. So they don't necessarily know, to borrow your language, to dial this back for our CROs, and CROs will absolutely understand this. They're coming to us in the same way that they would come to CRO. The only thing they know is something came by and hit them, knocked them down, ran over them. It might have been a truck. Okay, they, probably was that truck that they saw as they raised their head up off the pavement. So we don't always know, the client doesn't always know that there's an FDCPA matter there. We're attacking it with the view to first stop a judgment and therefore stop a garnishment or levy or an execution. And of course, if it's not on the reports yet, maybe get in the way of that bulldozer and prevent there being a judgment rolled out on the reports. But our first line of attack that we like to see is what our CROs are seeing, and that's looking at the credit reports. And one of our biggest challenges, no surprise, is actually getting our prospective clients early and often to go and pull their actual reports. And
that's kind of challenging, getting clients to provide documents in any industry.
We've tried a number of approaches. I think we've got something going now that's really well, in that we have an individual who we go ahead and make the introduction. I'm the attorney. This lady or this gentleman is going to be calling you and going to help you get access to your reports. And
that's right.
It really, the key in helping the client, and I know that all of our CROs know this, the key is getting early on into those reports and beginning to mine the reports to look for gaps in reporting, anything that's inaccurate or incomplete. I know they're thinking, gosh, it sounds like a broken record, but that is so powerful, because as you look through the reports and you find any flaws, in particular if you find flaws that have to do with biographical data, variations in Social Security numbers.
Now you're talking my language, Blaine, because
correct.
My spiel.
That's the important thing to remember, is that everything we do whether you are a professional in the CRO industry or an attorney, at the end of the day, it's all about that. It's all about the data. It's really all about the data and being disciplined enough and steadfast enough to go get the data and dive into the information and dissect it. And then after that, there's a number of approaches that work. You know, there's your very unique and helpful, and many times helpful aspect of Metro 2 guidelines and whether or not the reporting comports to the industry guidelines, which sometimes we use in litigation, sometimes we don't, but it's always in the background. It's always relevant and important. And then there's the more mundane thing that I find myself doing a lot is sitting down with the client and looking, you know, literally month by month through these entries and saying, what is this, you know, and then of course gaining the knowledge to know what is supposed to be in that report and what's not, and knowing when you're looking at something, there are things now that when I look at in a credit report that 5 years ago wouldn't have made any sense. I wouldn't have seen the problem because sometimes the problem is the omission of the data.
That's right, exactly.
Right, and that's sort of that's where the magic comes in, and that's why, you know, Stephen Palmieri, looking at a document, is able to see something that an attorney might not see, you know, or you know, any one of a number of our CRO guys, or maybe I see something and it's not that you wouldn't see it, but we see it in two different lights. But when we collaborate, we can get a bigger picture of that.
So we went from FD CPA, and you dialed it back to my world, which is credit reporting, and then, you know, Metro 2 being the industry standard. And it's not what you see, but it's sometimes what's missing, what you don't see.
But here's the beauty of this, though, is that if we get into that data early, not only may we find the seeds of a fair credit reporting act violation, but we oftentimes can look into that data and see that there's patently false reporting going on. You know,
so let's talk about that. You know, so under the FDCPA, obviously reporting false credit information is a violation, but under the FCRA, you have to report false information with malice or willful intent to injure to kind of open up that can of worms. So when you were referencing false information, were you referencing kind of debt collection?
I had reference there to the fact that frequently early on in defending, let's say you're defending against an original creditor, you have very little leverage. You know, Bank of America, you know, I show up and I'm, hi, you know, here I'm Attorney Dixon. I'm for Sam Smith over here, you know, BOA versus Sam Smith, you know, speaking to opposing counsel, and they're looking at you saying, well, hey, how much is your client willing to pay? And you're like smiling and saying, well, right now, nothing. And, you know, that's not what they want to hear. Or maybe you have a debt where there is a desire to work it out, but the original creditor is telling you that they have no interest in, and that's more common. You know, you're trying to assist someone, and yet the original creditor is not willing to work with you. Well, what do we do now? Well, let's go back and look at the data, and let's go into the credit reports. Let's find the flaws, and maybe we find something that's helpful enough that shows that they've been reporting false information. Then we've got enough leverage that we can go back. Maybe we file a counterclaim.
So I mean, if we're looking at the data, you know, how do you make your legal argument that they've crossed the inaccurate and incomplete line, and they have now squarely placed themselves in the false information line? I mean, because, you know, you can very clearly say, oh, well, it's reporting as a $500 balance, but it's really $750.
Well, I'll tell you, one of the areas may be easier for us to see. It's not the only one, but maybe easier to illustrate is where you have someone who's satisfied maybe they came to an agreement before they came to you. They satisfied an agreed judgment, and it inadvertently gets sued on again. Maybe it gets resold, but it pops up, and you have a situation where you have someone call you and say, wait a minute, you sent me a letter, or you reached out to me, however you reached out, and you may not have been sued. I've been sued. I paid this. And then you're like, well, let's slow our roll and look at this. And you're looking, and lo and behold, there's, you go back into the records, there's a debt that's been satisfied, and it was satisfied.
I mean, is it fair to say, I mean, you're kind of sort of describing, I think, what the bureaus would call kind of like a legal conclusion instead of an accuracy conclusion. I mean, if you're saying, well, this client's coming to me and this thing was like legally, there's a judgment or something was satisfied, is that where your comfort zone is for saying false information versus, well, it's inaccurate and therefore it's also false just because how can
it's false because it was known to the party who's suing that they had an agreement, and if it's nothing else, it's a breach of contract, right?
Yeah.
Whether or not I'm going to sue on that, travel on that theory under a fair to collection context or not, they still breached their agreement. And,
one thing I love about our good friend John Watts is that he is not afraid of Metro 2 data error lawsuits as long as the lawsuit makes sense. If he can show some sort of damages, things like that.
Well, that's correct. That's correct. John's mantra, and the one that is really we will never stray from, is we want an objective error. Okay. We can talk about theories until the sun sets and rises a couple of times, but at the end of the day, if there's an objective error and it's being published as fact, but it's clearly not correct, and it's known to the defendant, they have a problem. It's out there, and the individual is harmed.
Is it true that you and John, you guys interviewed to be Johnny Depp's attorney? The publication of false information, you guys just lost the cut just by his attorney said he had by just a smidge.
Well,
is that true?
The truth is about 2 minutes into that drinking contest with those other lawyers, we decided that they were able to drink much more vodka than we were. And we decided to back off in deference to our livers and allow these other people to handle it.
There's certain kinds of published false information that you don't want to sue for, but what you do like to sue for is what most people don't like, which is credit reporting, publication of false information.
Well, now, the beauty of what you just said is so true. If I had $1 for every time someone had called me and said, the creditor did this is so wrong. The Old River Credit Union in Nashville, they did this, and this is wrong, and this is wrong, and this is, and the problem is that even when they're telling you the truth, and this is the difficult thing for us, until we can find the smoking gun in the evidence, in the reports. And this is why we always say, go back to the reports. And God bless people who use Credit Karma and, identity. There's a play. And what I tell folks is that's a great radar. It's like the little radar app on my phone. It's great. I mean, okay, look, it's raining close by. It's liable to rain in the next 20 minutes. It's 90 degrees outside it's 110 degrees, and I probably need to get my ass inside and under an air conditioner. But the question is the relative humidity 72% or 90%, or the pollen count or some other thing, the winds are a certain speed, then I probably need to go to the government report like I would go to a NOAA weather report and get the specific facts.
Well, that's a good point. I mean, because you mentioned it's got to be published. That's kind of where the defamation type, error, you have to be damaged, so to speak. I mean, obviously we all know that the FCRA, the way it was written and intended, is that it's a procedural statute, and so if the CRAs or any of the participants procedurally screw up, i.e., they don't give you a full file disclosure that contains your full file, or if they don't properly reinvestigate, the way that the spirit of the law was, that's why they stripped away, like defamation, negligence, invasion of privacy. In lieu of that was you could sue them for procedural errors, right? But, here we are 50, 60 years later, we've got case law because of this beautiful legal system within which we operate, where you still can't sue for negligence, defamation, unless there's malice or willful intent. But now it seems you still can't also sue them for procedural issues unless, to your point, John wants there to be an objective error. So you're in a much tighter position now than the spirit of the law, was, I guess, originally intended. But
being put in a tighter box, though, is not always a bad thing, and I'll tell you why. Because it causes you to focus. It's like the difference between bullets and bombs. And so if the law forces you procedurally to focus, then our discussion about objective error, and and also the repeated committing of that error, the month by month misreporting of that. I have one right now that I can't say the name. It's ongoing, but so there's a simple FDCPA claim, and the lawyer, from a large, well-known, tall building firm, trots out and says, "Well, your claim's not even timely. They discovered this," and she thinks she's being really sharp and named something that's slightly over a year, and then you point out that, wait, every month that you continue to publish and continue to do the same thing and commit the same objective error, it's a fresh clock. And so it's not always a bad thing. Sure, it would be great but at the end of the day, I had an accountant tell me something, and my wife is also an accountant, and she said, the hard thing about the law that I see, she said, all the time you're talking about all the wrong that gets done. And she said, the thing I like about accounting is the math doesn't lie. The numbers don't lie. And so when you can take this scientific principle that something that is, inaccurate in a way in which can be shown in black and white, and almost mathematically on a ledger sheet, that's extremely powerful, because that will get you over the summary judgment hurdle, which for our CROs probably already know this, but that stage in the litigation where we call it the put up or shut up.
Right. Well, and I think that's where the Metro 2 comes in to help from the objective inaccuracy side. You said earlier, sometimes you'll use that in cases, sometimes you won't, but it is the industry standard. And I think if a lot of CROs, again, our folks listening here, even consumers, if you look for the errors, and the Metro 2 really is just a playbook. Really, it just shows you how do you read accuracy. That's really what it is in very simple terms. You're disputing errors. Where do you find the playbook? Well, that's their industry standard manual. Oh, well, your payment history should report consistently and consecutively, like their own manual says that. So that's how I view Metro 2, is really nothing more, nothing fancier than the manual for reading a report, understanding how a report should read. So, if you could find yourself putting together good quality disputes, pointing out those errors. I know John likes to do the same thing as I like to do, just put every error on notice the first dispute. We just blow them up with everything that's wrong. and wait for them not to fix things, and then you've got them out of compliance there. And I think that's an issue that a lot of CROs have, is sometimes they just don't put the time into doing those kinds of disputes. They may just be a much simpler thing, but
that's a critically important thing that you brought up. It is not easy, neither is it fast or quick to write a quality dispute letter. These can be I don't want to call them a challenge, but these can be time intensive, and ought to be, because of the amount of information that you're having to look at. So it's not. There's certain categories of things that you're looking for that you could easily make a punch list and just go down, from top to bottom. But in terms of actually fleshing this out and putting this into a well-written dispute letter is not always easy. So don't feel bad if it's not the simplest thing you've ever done, because it's not. But
it does take some work. Of course, that's why we kind of came out with the Palmieri system software to help. Now we use the credit monitoring reports right now. We don't have it yet where we can pull in the annuals, but it pulls in the reports. It lets you automatically generate the letters with the data in the letters. Again, it's credit monitoring data, but still, I mean, it's definitely a good start, right? And if because a lot of the
I think it's important to mention that probably if I were going to use that, I would probably use that and then have my exhibits pulled from the annual reports, and then take a marker. And I've seen it done different ways. And one way I like to do it, I think John may do it on the actual credit reports. Make circle over the take that field that is important and circle it. And it would be
highlight it.
It would be very, very difficult to for a national CRA and their analyst or agent, I guess is a more appropriate word, to ignore that. And a lot of what you're looking for there is, are you putting them on fair notice? And the two fundamental rights in our jurisprudence system are notice that there's a problem and a right to be heard. And so in this under the Fair Credit Reporting Act, when you're putting them on notice, the more specifically you can point to the flaw and any information you have to support your position, I say go for it. Put it in there, because if you go overboard and put too much quality information in there, there's still way better than a 50-50 chance that they just parrot and come back with their data conformity check and tell you, we find this accurate. In other words, they're just going to blow right on by it. And
you don't suggest that the CRAs have anything less than reasonable procedures to assure maximum possible accuracy, do you? Blaine?
Well, I'm not saying that, but I'm just saying that like if the trained Brazilian parrots that they have that are on the line, are left to their own devices, that a large percentage of the time, far better than probably 50% of the time, they're just going to spit that line out that this conforms. And
exactly, it's a big mill. And I mean, to the point though, if you could find an objective accuracy, which it doesn't have to be. I mean, it could be almost anything when you really know how to read the data, honestly. I mean, it could be missing data, because especially if you tie it back to the credit scores, which are algorithms which run through the data. the data's wrong, and then you've kind of got the black hole secret sauce of what FICO is. So it's like, well, Your Honor, I mean, we don't even really know because they won't even tell us what the algorithm is, but it's supposed to be derived scientifically from good data. So if my client's credit report is missing all these payment histories or missing first delinquency dates or inconsistent balances, we don't even know.
And
But,
you know what, you brought up a great point because Your Honor, if we have to question the data, how accurate can the result be? Right? If the ingredient, if you're making soup, if we're making credit soup, and the credit peas are bad. Hell, maybe they're not even peas. Maybe they're oats, or maybe they're small pebbles from a local stream. We don't know what they are, but how can we trust the soup? How can we trust the cake if the ingredients themselves are tainted?
It's like spam. You're like, how can I trust this thing when I don't even know what's inside of it? I hear exactly what you're saying, Blaine.
Well, we know one thing: it didn't necessarily come from a pig. It's just greasy and it's in a can.
That's right. But so as we kind of take this one in for a landing, my goodness, almost 5 Central here, 6 Eastern. Man, we've been here for almost an hour. Let's kind of take this thing home for our CROs, for our viewers. And so the thing I like about John, and you obviously you collaborate with his firm, and you as well. I mean, he's not afraid of credit reporting error clients. If he can say that there's an objective error and damages. Which the other thing I like about John is that, he comes from a personal injury background, which is like, I'm damaged because my neck hurts, right? And so with credit reporting, a lot of attorneys would like to say, well, can you show me how you were financially damaged? Well, I applied for the mortgage. And they said that I was going to have to pay 4%, but if my credit were accurate, which means if this stuff had been deleted because they didn't fix it, I would have gotten 3% instead of 4%. That's a numeric financial damage, right? But correct. John, he'll take the personal injury stance.
And we love those. But you know what we also love? We love it when they start talking about damages. And I always stop the conversation with opposing counsel and say, that's great. But when we get to trial, I'm really not going to be saying the word damages. We're going to be talking about harms and losses. Let's talk about how Sarah Smith was harmed. Let's talk about the fact that she felt shamed in her own family when this came to light. Let's talk about the sleepless nights. Let's talk about the marital instability. All of these things are part of the preambles to these statutes that talk about, in the Fair Debt Collection Practices
That's Act. Where Blaine goes up before the jury and he's like, okay, I gotta get the tears. Okay, I gotta.
Well,
Your Honor, you see the tears right here. Okay,
that's right.
He's got to get the crocodile tears going on.
Oh, well, I'm telling you, but I'll make it personal.
I'm still tearing up. You see that right there? That's a genuine iced tea tear right there. But the jury will not know the difference.
I want to take you back to 1987 when. And this was one of my primary motivating factors in going to law school, Stephen. This is why I'm a consumer lawyer. We'll title this under why Dixon was ever a consumer lawyer in the first place. So in 1987, and my mother has stage 4 aggressive, HER2 type negative breast cancer, and she's given a not great diagnosis, prognosis. Of course, from which she ultimately survived and lived another 30 years because we don't lay down. That's and I tell my consumers that, look, we know what bad things look like. But bad things that look bad, things that feel bad, things that are bad now don't always end badly. And I'll say this about harms and losses. Had I known what I know now in 1987, that the debt collectors would have been sued under the FDCPA and would have lost. And this is one reason that they try these cases you know, they call the home, they berate the spouse, they get the wrong person on the line. Heck, they get the right person on the line, but it's on speakerphone. Everybody in the room hears it. And here this person is being humiliated. And as much as they would like to tell us that they have cleared up those problems, they haven't cleared up those problems. And so our people are out there, and our CROs probably are pretty cognizant of this and know this, but always be aware of the human cost of what's happening to your clients. They're coming to you about their credit scores, but you know what? A lot of times it would probably be worth it for our CROs to be saying, hey, what sorts of humiliating things have they done to you to try to get you to pay this alleged debt? And we'd be surprised. It's still going on. But I remember my mother in the middle of her fight for her life, debt collectors calling and attempting to humiliate her over the hospital bills that were needed, that were connected to the treatments that were needed to ultimately save her life. So don't ever be afraid to stand up for your clients, even as CROs, and say, you know what, enough is enough.
Yeah.
And you've got you've got all those protections under and we're not even having a discussion about Reg F, but Regulation F, you got this wonderful set of tools where you can say, please don't do this. This is not convenient. And we hopefully have some tools now a little bit more helpful to sort of stave these things off. But you're right. It is a little bit emotional. But in a world where the black hats have come after and have had great help from the high court about chipping away at damages, but they have a very difficult time eroding your client's story. And the beauty about that is your client's always going to have a right to talk about the harms and losses associated with what was done to them. So anyway, yeah, I'm a little bit of a bleeding heart that way, but I like to think
it takes to be a consumer protection protector like you. Didn't you like swear that oath you'll never represent a business in any way whatsoever? Isn't that like, are you a member of NACA?
Absolutely, and that's absolutely true. But I like to think that's okay, because that way the kind of people who want to go chasing down something as easy as sitting in a chair and listening to the judge say default all morning, well, maybe that just keeps them over there where they belong in the dark, and gives room for those of us who care to do what we do. But
I mean, on the flip side, though, when you get good at being a consumer financial protection attorney, I mean, the statutes are designed to where you can take these cases total contingency, because the statutes are designed where the losing party pays attorney's fees plus,
absolutely. And we're learning every day that some of the tools that we used to hate, like arbitration, are actually swords in our hands. So there's a great term called swift boating. And, a swift boating approach is where you take what the defendant believes is their greatest strength, and you turn it into a sword, and you turn around and you lay them open with it, disembowel their case.
Well, on that note, I couldn't really think of a sweeter spot to take this one in for. Well, I say we'll take it in for a crash landing on the disembowel comment, but
she's coming in hot.
But it's always a pleasure, Blaine. You're always welcome to fill in for John at any point in time when he's out fighting.
Well, thank you. As you can see, I'm no John, but we sure love fighting the good fight together.
That's okay. It is, you are unique in your own Blaine Dixon sort of a way, man, and that's what it takes. Everybody's got a kind of a specialty, So, for those of you guys watching us, if you guys want to get in touch with Blaine, how can they get in touch with you, my friend?
Give me a call on my or text to my personal and business cell, area code 615-440-3746. Or if you need something more detailed, shoot me an email to Blaine, Blaine, at Wattsherring, WATTSHERRING.com. Blaine at Wattsherring.com.
So be sure you reach out to Blaine. Good guy. I've known him for a couple of years now, and man, I knew him back before he was hugely successful partnering up with John Watts. I knew him when he was just an average guy, and you know, if he would talk to me still now, when he talked to me then, you know, he's just a good old boy. So
I knew myself before I was hugely successful by coming on to Stephen Palmieri's show.
There you go. You know what? Yeah, we
just look, if you're going to think about me or mention me to your friends in the CRO world, just tell them you know the Billy Bob Thornton of consumer law.
There you go.
All I'm saying is that, you know, if they do something wrong to your clients, you just tell them, hey, you should not have done that.
That's right. That's right. And of course, if you guys are watching and you like what you see it here, we also have our CRO pre-lit training course, 30-day free trial. It's just $99 a month. After that, you can go to creditrepairtrainingcourse.com, sign up there, and yours truly will reach out to you, get you personally onboarded. So that being said, we will wrap this one up. Blaine, thank you for coming in here. Those of you guys watching us, thank you for your continued fandom, and we will see all of you guys on the next show. You guys take care.